States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5328. Attorney General of the United States Appellant versus Stephen A. Wynn. Mr. Minta for the appellant, Mr. Luskin for the appellate.
Mr. Minta, good morning.
Good morning. May it please the court, Your Honor. Joseph Minta on behalf of the Attorney General. I'd like to reserve 2 minutes for rebuttal. Foreign Agents Registration Act is a critical tool in protecting this nation from malign foreign influence. But the district court's unduly narrow interpretation of Section 618F guts the government's ability to civilly enforce the act. The district court's interpretation should be reversed for 3 reasons. First, it's contrary to the statute's plain text. Second, it ignores the act's history and structure. And finally, it defies the act's express purpose of ensuring disclosure of foreign efforts to influence U.S. policy. Starting with the plain text, Section 618F begins with 2 subordinate clauses, and both sides agree these clauses should be given independent meaning. The way to do this is to read the first clause as applying to ongoing violations, while the second clause applies to past violations, such as Wynn. The district court's interpretation, however, fails to read the statute as a whole. Congress passed—
Where did you make this argument in the district court?
Your Honor, we noted in the district court our reliance on Section 618F, and the district court understood that argument, and that's why it reached the whole—
I understood that that was your cause of action. Didn't understand that you were reading, at least I'm not aware of where you argued below, that 1618F is actually 2 distinct actions, one of which covers retroactive conduct, and one clause which does not. Did you make that argument to the district court?
Not in that level of detail, Your Honor.
What do you mean that level of detail? Did you make the argument or not? Was the district court on notice of the argument you're presenting to us?
We did not present the argument in that framework, and as the district court noted, we didn't unpack the Section 618's text.
Right, so the district court had no opportunity to consider the argument that you're now presenting to us.
No, Your Honor, but the district court nonetheless made a holding that the government is required to allege an ongoing violation of FARA in order—
It did that without hearing this argument. You're talking to me about plain text and everything, but it wasn't plain enough to have been argued to the district court. And so why are you allowed to argue it now to us in the first instance?
2 responses, Your Honor. First, the forfeiture doctrine doesn't apply where the district court nonetheless passed on the issue below, and there's no dispute.
Did it pass on your argument that the second clause of this is meant to be retroactive?
It held that we had to allege an ongoing violation, and our position is that the second clause—
Let me ask the question again. Did it pass on the argument that you're making now that the second clause is operates retroactively?
It did not make an explicit holding on—
Because it wasn't presented to it.
That's correct, Your Honor.
You can't argue it before us because the district court passed upon it. The district court wasn't presented with it and didn't consider it. So what is your other argument for why we should consider it?
The forfeiture only applies to new claims on appeal, not new arguments in support of a consistent claim. And our consistent claim has always been that Wynn should be required to register and that the Attorney General is empowered to bring this civil suit to require him to do so. Our Section 618—
your argument's got to be more sophisticated than that, given our McGough decision. And so your argument below, as I understand it, was civil versus criminal. But your argument here now is entirely different, and that is that 618F is a 2-parter, and that there's just a distinct statutory authority apart from the civil authority itself. If the civil criminal distinction, there's this specific authority to reach retroactively to require registration.
I think
how's that not a new— these are fuzzy lines, I know. How is that not a new claim?
So our claim has always been the consistent single claim that the Attorney General is empowered to bring this suit, and that it is no defense to that suit.
We define things that it would be, my claim has always been my client's not guilty, and then you can argue anything. You never argued to the district court below, and we don't do it at that level, 30,000-foot level.
No, I think
worried about how the district court going to feel sandbagged here if you're coming here with what I think would you characterize as a plain language argument that court never had a chance to hear.
I think that's very similar to the situation that arose in this court's decision in Shea v. Carey, where the claim was framed as the State Department discriminated against me. And the appellant was allowed to raise additional arguments in support of that particular claim. In particular, an argument focused on a recent Supreme Court decision that was before the district court and the district court acknowledged. But the appellant had made a different argument in support of his discrimination claim and argued under a different framework in the district court.
Is that based on intervening Supreme Court precedent?
No, the Supreme Court precedent was already on the books at that point. He simply changed he argued that the framework that he used in the district court was simply inapplicable on appeal. And this court declined to find forfeiture under those circumstances, characterizing it as a new argument rather than a new claim. And once you reach the merits of that argument, I think that it's clear that the district court's interpretation is contrary to the purpose of FARA, which is ensuring disclosure of foreign efforts to influence U.S. policy. And
the ongoing interest is in assessing advocacy that might have been engaged in by Mr. Wynn when he was an agent, to the extent that that information remains publicly available, that it would also be important to the government to have the context for that information?
Yes, Your Honor, and to the public for any policy decisions that the government ultimately makes, whether that happens now or down the road. The public needs to understand the factors that went into that decision, and that includes all of the disclosure requirements that FARA requires when foreign agents are trying to influence U.S. policy.
And under Mr. Wynn's reading, the government could have prosecuted him criminally at the time when it chose instead to bring a civil suit for injunction. Is that right? So
the criminal provisions have an additional element of willfulness. If the government could prove willfulness beyond a reasonable doubt, I believe that both sides agree we were within the 5-year statute of limitations that McGough set out. The civil provision does not require willfulness, and that's why it's an important additional tool for the government to have to enforce the statute in instances either where willfulness can't be proved beyond a reasonable doubt, or simply where the government feels that the less severe enforcement option of a civil suit is the more appropriate way to address the non-compliant.
And I take it, here there's no statute of limitations either for the criminal or the civil, but I take it there's no sort of residual statute of limitations available for civil non-disclosure violation the way there is for the criminal?
No, Your Honor. There is a default civil statute where the government is seeking damages, but not where the government is seeking equitable or injunctive relief. That's all that we're seeking here. I think that's important to note that Section 618F isn't designed to be punitive. It's designed to ensure compliance and make sure that the public has the information that it needs. And you can see that even in the history of FARA that we set out in our brief, where in 1950, Congress amended FARA in order to essentially reject the argument that Wynn is now making in the civil context, but in the criminal context. It was only later when Congress added Section 618F, and it did so with that history in mind, writing it to address, again, both current and former agents in the ways that we've explained in our brief. Finally, I also want to point to several structural features of FARA that support our argument. In particular, the fact that several...
your textual argument under 618F, and that is, I'm struggling with how you read what you call we'll call it the second clause as applying retroactively, because it uses the same present tense verbs as the first clause.
Yes, Your Honor. There are numerous statutes that are phrased in the present tense, but nonetheless apply to past completed conduct. You can look at the SEC's...
Well, then you would say you're covered by the first clause and the second clause.
I think that in a vacuum, you could make that argument. I think when you look at the two remedies that Section 618F includes, that further supports our distinction. The first set of remedies discusses either enjoining the failure to register or enjoining the agent from continuing to lobby. The second set of remedies only discusses an order for compliance. And that makes sense when you're only dealing with past conduct and there's no further activities by the agent.
Well, no, that makes perfect sense if you're dealing with ongoing conduct.
I think the first clause has already covered that.
Well, no, I think they're different. I mean, the first clause covers acts. The second clause covers omissions. That can be present tense and even anticipated in the first clause. The first clause applies to persons. Second clause applies to agent of a foreign principal. So they have different subjects and they have different scopes that they cover, but they are all present tense. There's no language here at all that suggests retroactivity, in particular, given our McGough holding that you are no longer an agent of a foreign principal once your service in that position terminates. There's be no way then to have the second clause, which requires you to be an agent of a foreign principal. That way, you're only allowed to enjoin an agent of a foreign principal to fill out a form under this clause. And we held in McGough that once the relationship ends, you are no longer an agent of a foreign government. So there's different purposes for the clauses. They have different subjects, and the injunctive relief targets the named person, the named subject, which isn't going to cover folks once they've stopped being an agent of a foreign government, at least under McGough. We're stuck. I mean, we're stuck with that as a panel.
I agree, Your Honor, that McGough is binding on this panel, but I think the operative point of analysis is at the time Wynn violated FARA, he was then acting as an agent. And our position is that triggered him right then. And that triggered the Attorney General's enforcement power. And a foreign agent isn't then empowered to cut off that enforcement power by later activity.
When you say that that there's the different remedies, and one of the remedies is to enjoin compliance, order someone to comply, who is the object that can be ordered?
It's the person that was acting as an agent.
No, it doesn't use the word person. It says for the purposes of enjoining someone to comply, the omission clause, it says you may enjoin an agent of a foreign principal.
Yes.
Okay. And at the time you're trying to seek, you were asking a court to enjoin right now someone who is not, at the time of the injunction, an agent of a foreign principal.
At the time of their non-compliance, they were an agent.
I know, but we're talking about the remedy here. And the injunction, as you said, the remedies track the structure. And the only object, the only person who's an object or entity is this agent of a foreign government. There's simply no one to it. It doesn't say you can enjoin a person. You use person in the first clause. It does not use person in the second. So there's no capacity to enjoin a person to comply with filing forms or registration forms, only an agent, and you don't have an agent.
Your Honor, we have an agent at the time that Wynn was non-compliant. We agree with McGough holding that that obligation has ended, but we are asking the court to order him to comply with his delinquent obligation to register at that time. And I think that that's important given the structure of FARA. I apologize, I see my time.
Although, let me just ask about that, looking sort of more broadly at the way the provisions of the Act fit together. In 615, the agent is obligated to keep records for 3 years.
Yes.
Following the termination of the agency. And it just seems that that is another indication in the statute that the reporting requirement is not meant to survive indefinitely, because if you've turned over or, dispensed with the records that you would need to file 10 years down the road, it just seems to me to support the notion that Congress wasn't contemplating an indefinite obligation to comply.
Your Honor, what we're ultimately seeking here is an equitable remedy. If, because of the passage of time or any other factor, it would be impossible or unduly burdensome to comply with the injunction, then the court could take that into account in crafting the remedy. But none of that applies here, where we brought suit even within the criminal statute of limitations that this court set out in McGough. And the last point that I want to make is many agents of a foreign power act only for a short period of time. And in those instances, there simply isn't an opportunity to bring these kinds of lawsuits while they are still acting. But consistent with the purpose of the statute, this court should read Section 618F to also empower the Attorney General to bring civil suit to ensure those agents' compliance with the statute as well.
It does seem potentially dysfunctional, and the relevant circumstances or typical circumstances may have changed given sort of the internet and how information has a much longer half-life than it did at the time, for example, with McGough. I mean, it struck me that McGough talks about needing this statute to protect against subversive activities, whereas now it seems more like the government's interest is in providing context for advocacy information that may be out there still, that endures, things that Mr. Wynn may have said that people might be taking into account now. Like that's kind of a new problem since McGough.
I think that it's a different version of the same kinds of national security interests that are.
Oh, for
in
sure,
play.
but it just seems like and I guess one question that I have for the government is how we don't have cases under this statute very often. Is this provision used very frequently, I assume?
The criminal provisions are being used more frequently in the last several years. In particular, there's been a number of high-profile prosecutions along those lines. This is, as the district court noted, one of the first civil actions involving Section 618F. But the government does recognize foreign malign influence as a national security threat and is working to use these and similar statutes in order to combat the new problem as you framed it.
And I don't know if this is something that you have information about or feel is appropriate to share, but the government could bring an indictment and then resolve it if the defendant is willing to provide the information. I mean, there's something perverse about the longer availability of a criminal claim when the core interest in the statute is in the disclosure.
Exactly, Your Honor. It's backwards from a normal statute to have the civil remedy be much narrower than the criminal remedy, but that's the implication of the district court's holding here.
Well, and perhaps of our holding it.
I have some questions.
Yes.
Can you go back to 618F and could you give us an example of what would fit the language or otherwise is in violation? As Judge Millett said, the first one is commission, the second one is omission. What's left or otherwise is in violation?
I think otherwise is in violation is intended as a catch-all in order to ensure that all past violations, as we read the statute, that's part of the second clause, which applies to past violations, and it ensures that any past violation of FARA, whether it's a failure to register or a deficient registration statement or a failure to maintain books and records or a failure to file a supplemental registration statement, all of those different kinds of FARA violations need to be able to be remedied by civil injunctive actions as well as criminal prosecution. And so that or otherwise language ensures that it all comes within the Attorney General's civil enforcement power.
So you can't think of a discrete otherwise violation.
So I think the first part of the second clause does cover most of the issues because it says fail to comply with any provisions of the chapter or the regulations. And I think that would pretty much be all the violations, but Congress wanted to make sure that it had this catch-all provision just to cover its bases.
Okay, and then I have two questions that I know we're not dealing with whether or not Mr. Wynn was a foreign agent, but do you take the position or does the department take the position that a quid pro quo is necessary?
Your Honor, no. There's a variety of decisions on the level of control that a foreign principal needs to have over the agent. And this is something that was raised in Wynn's motion to dismiss as a separate ground that we hadn't adequately alleged that. But we do not believe a quid pro quo is necessary for foreign agents.
Okay. And then the final question, do you know the status of the legislation that is trying to fix the McGough problem?
I'm aware that the legislation has been introduced. I'm not aware of any further steps that have been taken with respect to that legislation.
Thank you. We'll give you a
And one assumes the government would want to add a statute of limitations for the civil violation to that legislation if it's going to proceed.
I believe that the legislation includes an explicit criminal statute of limitations. I don't believe, as drafted currently, it includes that civil limitation.
We'll give you a couple of minutes to reply. Thank you. Mr. Luskin?
Good morning, may it please the court. As Chief Judge Boasberg cogently recognized, the case presents a single issue, and that is whether an individual under this court's precedent in McGough who has no present obligation to register under FARA may nevertheless be compelled to register retroactively under 618F.
Mr. Luskin, can you get either closer to the mic or raise
Yes.
the podium? I'm so hard of hearing, and I apologize, but I want to hear what you have to say.
Don't apologize because I'm having trouble hearing you too. So, and as Chief Judge Boasberg ruled, that question is squarely controlled by McGough because McGough decided that Section 612A, the registration provision, the obligation to register terminates when an agency relationship terminates. And reading 618F, he concluded, therefore, as the court did in McGough, that because there is no present obligation to register, the injunctive provisions of 618F can't apply.
Mr. Luskin, can you respond to the apparent anomaly that I was raising when Mr. Minto was standing there about the government having a longer time window for criminal prosecution than for civilly seeking the record?
Well, I think I guess I wouldn't regard it as an anomaly, Your Honor, because it seems to me that because their criminal provisions and criminal penalties are intended to be more serious, what McGough called regarded as a howitzer, it makes sense that under those circumstances where the harm is greater, that the government should have a greater opportunity to rectify them and to deter them through the criminal penalty. So I guess I don't see that as it makes sense to me that the civil remedies, which are all framed in the present tense, all intended by their terms to bring an individual into compliance with the statute, should have a shorter term.
It's odd, given that there isn't any mala and say violation here. The crime is in service of incentivizing covered people to comply more than stopping some, harm to the public. I mean, it's very bound up with the primary interest, which is that the government and the public should be aware who's paying.
No, that's certainly correct, Your Honor, but it does seem to me that the public interest, once an individual has ceased to act as an agent, is significantly attenuated. The interests of FARA, to the extent that they are all revolved around contemporaneous disclosure with a 10-day registration requirement, with an obligation, for example, when it involves congressional testimony, that the committee be notified in advance. All of the obligations revolve around contemporaneous.
Well, they revolve around prompt, knowing at the time, of course, because that's when the person's advocacy is going to have the most audience. But when it then becomes part of a permanent record and people say, oh, Mr. Wynn, he was very involved in business in China. Let's look what he had to say. I mean, that's, his statements are still, no doubt, available on.
Well, of course, I'm not saying that there's no interest here. And obviously, and I guess this goes to the issue that the government has raised about there being some sort of loophole here. I think an individual who is acting as an agent is really engaging in a legal suicide act or an act of self-immolation if the government approaches him and he were to say, well, I'm very sorry, I'm terminating my relationship, or I terminated it last week, so you guys can take a hike. I mean, I think an individual does that once and the government prosecutes, and no one in their right mind would ever dare the government to do that again.
To the 618F issue, I mean, the district court did pass on the meaning of 618F, at least in some extent, and you take it to not be adequate preservation that the court referred to it as creating the cause of action.
And I can't do, I'm sorry. I can't do any better in framing what happened in the district court than to quote Judge Boasberg at page 199 of the joint appendix. And he says, if an interpretation of 618F exists, it would allow the government to compel Wynn to register today, notwithstanding McGough's interpretation of the registration obligation in 612A, the government does not provide it here. In fact, it does not engage at all with the text of that provision, or of 612A for that matter, beyond insisting that 618F is the basis for distinguishing McGough. I don't think the record could be any clearer that the government certainly asserted that it had a right to enforce injunctive provisions against Mr. Wynn, but it completely stepped away and passed on the interpretation that it pushes here, which is that 618F contains a present obligation to enforce a requirement that has since lapsed under McGough. That was nowhere raised or implied or suggested in the district court.
And I'd love to hear your thoughts on the same question that Judge Henderson asked of Mr. Minto, which is the relationship between, I mean, assuming that it is before us, which I'm not purporting to take a position on that by asking the question, your view about when the second clause would be triggered and the first clause would not already cover the situation.
Well, I have trouble, like Mr. Minto, seeing the otherwise clause as anything other than a catch-all provision. And we see that in other statutes like the general obstruction provision of 1512. But I do want to address the government's general view of 618F, which is the only way to read that rationally is that it includes two clauses, and one of them addresses present conduct and one addresses the past. In fact, there are two clauses here, the first one of which addresses persons, which is a universe of individuals who have not yet but may have an obligation to register, or under section 615, it includes officers and directors of corporations or other entities that are acting as agents. And the second clause addresses agents, which includes all of the ongoing obligations of an individual who has registered to supplement the registration, to retain records. The statute is addressing by its terms two classes of individuals who are subject to the requirements of FARA, and it does it in explicit terms. And to suggest that somehow that distinction is meaningless or doesn't exist and must be explained instead by a past-present dichotomy just simply fights the plain language of the provision. And obviously, I'm sorry.
Millett mentioned 615, and it talks about the obligation of an agent of a foreign principal to maintain records for 3 years after the termination of the relationship. So it refers expressly to someone even in the post-termination time of period of at least up to 3 years as still an agent of a foreign government. And so does that not suggest that the agent, at least as to enforcing sort of record requirements like this, those omissions that an agent can commit do not themselves, they can be enforced civilly, do not terminate at the time the relationship itself terminates? 615 is plain language.
I think that's right. And I think that the government could, in action, under 618F to enforce the ongoing obligations under 615.
No, if you want to enforce let's say the person has complied with everything, the relationship terminates, and they go, I'm not keeping these records for 3 years. What capacity does the government have to enforce that other than a criminal prosecution?
Well, I think under 615, because the obligation is ongoing, then 618F by its terms, through the use of the present tense, can be used to enforce it under those circumstances.
So it would just be a failure to comply by an agent.
That's right.
So 618's ability to enforce, to require an agent of a foreign government to comply with disclosure obligations continues for 3 years.
No, I think 615 only.
Relationship.
615 only speaks to the retention of books and record. I think McGough resolved the question of whether or not the registration obligation endures, and it said it does not.
But you're saying that other obligations, like this 3-year record retention obligation, could be enforced civilly through an injunction after the relationship is terminated.
I'm saying yes. I mean, obviously that isn't the issue presented here.
Okay, so but if that were the violation,
but that's right, because
then he obviously didn't retain records either. So if there can be an injunctive action after someone has ceased serving or terminated the relationship with the foreign principal, but you're saying there still can be a civil action at least to enforce this records requirement.
I think what I'm saying is that there has to be an ongoing obligation to be enforced. And in the case of 615, there is an ongoing obligation related to
Now, what about the
retention of
obligation
records.
to file supplements to your initial registration statement? McGough only dealt with the initial registration statement. And so,
I think that's bound up within 612 and covered by McGough.
because,
Because he has no current obligation to register as an agent.
and so, okay, so then, so all you're saying is that 615 can be enforced after the relationship has been terminated. Is there any statute of limitations on that? Civil, can be enforced civilly. What would be
Well,
the statute of limitations for that?
It's a question not presented, but I would think it would only be governed by the issue of latches.
Well, latches doesn't apply to the government. So,
That's right. That's their position.
so there'd be no, that's what the Supreme Court has held. So, there'd be no time limit on enforcing 615's record requirement. in
Well,
civil
it
action.
would be 3 years, Your Honor, because I think under this reading of 618F, which is to say 618F can be used to enforce a present continuing obligation. At the end of the 3-year period, that obligation ceases. Just by in the same way, in a parallel fashion, that the obligation to register under 612 ceased when an agent ceased to be an agent of a principal. So if the government were to come in 5 years later, say, we'd like to enforce the obligation to keep records for 3 years, I think at that point, the defendant would be absolutely correct to say, no, I'm sorry, that's 2 years.
It's just that it seems that there's a way of reading 615 as saying, when it comes to the particular obligation to maintain records, and by including creating records in the first place, as to that termination of the relationship does not terminate the obligation. And it's only as to actions such as interacting with the government on behalf of a foreign principal that that obligation terminates when the relationship terminates.
Well, I think under 615, it covers an agent who is registered. And so an individual who is not registered and has no current obligation to register doesn't concomitantly have an obligation to records. I think it's also worth addressing the fact that this construction of 618F is also consistent with the basic rules of equity, which is to say equity is typically reserved for addressing imminent or ongoing harms. And it is.
But injunctions are used all the time to require disclosure of information that should have been disclosed, all the time. So equity does not, when it comes to disclosure obligations, informational disclosure obligations, it doesn't require imminence. I mean, FOIA, every order to disclose under FOIA is something they should have disclosed when first asked by a court. And, disclosures under the Government and Sunshine Act.
No, that's correct, Your Honor. But
Federal
what I
Election
am
Commission
saying,
Act, those are all, so I don't understand that theory that injunctive relief requires imminent harm. The harm is that right now I'm injured by the fact that information wasn't disclosed.
well, it's a past harm, Your Honor. And I think that the language of 618F is very clear over and over and over again through the repeated use of the present tense, which the Supreme Court in Carr, quoting Waltney, called a kind of striking indicator of the intention that it be applied presently and prospectively, but not retroactively. That's an indication that in adding 618F, Congress intended to address the issue of ongoing
Injunction
or
here is-
prospective harm.
The injunction for failures is for an order requiring compliance with any appropriate provision of this relevant statute. And you agree that that would encompass a 615 injunction for past failure to maintain records.
That's right, Your Honor, but the last sentence, which talks about the scope of the court's authority to issue an order, refers back to the preceding clauses, all of which are framed in the present tense.
But you just said, you agreed it would cover past tense violation like 615F.
No, Your Honor, I think that I'm saying that it covers only ongoing obligations. That it does not address historical harms.
So if it's the 364th day of the third year, or it's almost to be 3 years, so it's a day before 3 years under 615F, and no records have been maintained for the preceding 2 years and 364 days, then you would agree that you could get an injunction under 618 to require compliance with that.
For 1 day.
Well, to require compliance.
It would require compliance because there is an ongoing obligation, which an agent, which is the
That
second clause
injunction
of
would
this.
continue after.
Pardon?
That injunction would continue
Well,
until compliance occurs, right?
under those circumstances, I think I would argue that since the statute itself only requires retention of those records for 3 years, that the court's authority would be limited to enforcing the terms of the statute, which is what 618
For 1 day?
says on
The
its
court would
face.
enforce
For
the
1 day.
injunction for 1 day?
For 1 day.
There are no more questions. Thank you.
Thank you.
Mr. Minta, why don't you take 2 minutes?
Thank you, Your Honor. I just want to briefly pick up on the discussion of other obligations of FARA that continue beyond the termination of agency. We talked a lot about Section 615 and the preservation of books and records, but there's another important obligation, perhaps more important, which is that agents are required to file a closeout filing within 30 days after terminating their agency. And that disclosure is particularly important because it lets the people know how the agency has been wrapped up and that those activities are no longer ongoing. Under Wynn's purported reading of the statute, that obligation would only be enforceable criminally. The civil enforcement provision that Congress intended to be the less severe option is simply unavailable. But I think it also goes to Your Honor's point about the definition of agency, that the statute uses agent of a foreign principal at various points to talk about people that were agents of a foreign principal at one time, but have incurred subsequent obligations.
Is that enough? What does that get you?
So I think that it responds to the concern about the subject of the second clause being agent of a foreign principal, and that shouldn't be a burden or a hindrance to reading that clause to nonetheless apply to past violations, such as Mr. Wynn's. I think that together, that gets at both the broader purpose of the statute of ensuring this information is out there and the narrower purpose of Section 618F, which is providing the government an option short of criminal prosecution to enforce these kinds of obligations. I also want to highlight, both with respect to the claim that these kinds of injunctions would only be available for 1 day, many agents of a foreign principal act for short periods of time. And to simply write off the Attorney General's civil enforcement provision in those circumstances, I think is contrary to the purpose that Congress had when it enacted Section 618F. We would urge the court to reverse.
All right, thank you.
Case number 22-1272 et al. Hospital de la Concepcion petitioner versus National Labor Relations Board. Mr. Fortney for the petitioner, Mr. Francisco Fitzmaurice for the respondent.
Mr. Fortney, good morning.
Good morning. May it please the court. David Fortney on behalf of the petitioner, cross-respondent, Hospital de la Concepcion. This is a labor case, and it requires this court to determine whether the changes in work shifts and assignments for certain hospital employees was covered by an extensive, very detailed management rights clause in the parties' collective bargaining agreement, and that clause which actually expressly authorized the changes that occurred. Under the contract coverage test, which this court established in the U.S. Postal Service case, actually 30 years ago, almost to the day, the hospital's conduct we submit was fully authorized by the literal language of the collective bargaining agreement, and therefore we, of course, would ask that the board's decision and order be vacated. Let me just take a moment and go back to what the underlying facts were, because facts matter in addition to the contract laws. These changes occurred during the onset of the global COVID pandemic, following the issuance of repeated executive orders by the governor of Puerto Rico. The orders restricted the hospital's operation to essential services, including COVID responses. And it was only following the issuance of the third executive order by the governor that the hospital undertook the necessary reduction in hours of certain bargaining unit employees who were not required to perform the limited authorized operations. And managerial employees, that is non-bargaining unit employees, also were subject to similar revisions and restrictions in their work hours. I noted the disposition of the case not only, we believe, is controlled by this court's ruling in U.S. Postal Service, but the National Labor Relations Board, which after some time did adopt this court's rule in MV Transportation, that was in 2019, and specifically embraces this court's test, noting that the contract coverage language really requires us to look at whether the conduct is within the compass or scope of the
Mr.
agreement.
Forney, the board did not rely on or did not embrace your contract coverage argument. And I think that's because there's a well-established difference between changing shifts and changing work hours. So if you could address the argument that the board did accept, which was about unilateral reduction, that would be helpful.
Be happy to. So the board principally, as I understand the argument, because it did change, it's kind of evolved as it's gone along, but currently in the brief, the board argues that there was a practice relating to 40 hours. Prior to that, the board had argued that the contract clause required 40 hours. But in any event, the record demonstrates that the 40-hour work week was in fact, but not the practice and not required by the contract. Specifically, the union witness testified that he worked less than 40 hours. No grievance,
My
no
understanding
count.
is that the ALJ made a finding that the practice was 40 hours and adverted to the contract clause as a kind of baseline piece of evidence on that. And indeed, the evidence in the record that the ALJ accepted was what the board embraced, that there was a practice of 40-hour-a-week scheduling. And I know you have a witness who said that on 2 or 3 occasions, he was allowed to go home early. But I take it that the ALJ and the board did not accept that as showing that there was no such practice.
Also, the part-time employees that regularly worked, did not work 40 hours a week, was part of the record. Additionally, the contract language does not support, and respectfully, there is no deference owed to the board or the ALJ on interpreting collective bargaining agreement. Under Lytton, that is what this court must do. And if you read the collective bargaining agreement, these parties, very sophisticated, detailed collective bargaining agreement. The parties knew how to mandate certain conduct, certain actions, in contrast to the provision for a, quote, regular work week.
Right, and they're not arguing that,
Right.
that it's mandated. They're arguing that it was a practice and that the employer made a unilateral change without bargaining.
And tied to the concept in the contract of a regular work week. Obviously, in responding to the governor's orders at the outset of COVID, this was certainly not a regular work week. It was not. This was not a regular schedule. And I think that the additional points with respect to the contract that need to be considered include that there were mandates in the contract, very specific. 2-day rest period will be provided. Meal breaks will be provided. And there's a litany of Christmas.
Right, but that's
bonus.
an argument saying that the 40 hours wasn't a requirement. But as I take it, the board is not arguing that it was a requirement and that the employer violated it. They're taking it as a baseline. And indeed, I think it wasn't until your reply brief that you argued that there's no substantial evidence supporting the 40-hour per week past practice. And indeed, the letters you sent to the employees suggest that you thought that there was a past practice and that the hospital was seeking to change that in light of COVID. So given our rules about preservation of arguments, has the challenge to whether the finding that there was a past practice of 40 hours been adequately preserved if the first time that you raised that challenge is in your reply brief before us?
Well, respectfully, in terms of the board's argument, that was raised in their brief here. And I would just put that the tension between arguing a practice which conflicts with an express provision in the collective bargaining agreement. Practice cannot amend the collective bargaining agreement.
What does it conflict with?
It conflicts with the specific provisions going back to the management rights clause. Nothing limits without any limitation whatsoever. There's a normal, very broad language, and then it goes through and gives a litany of actions that can be undertaken unilaterally. That has been agreed to by the union. So notwithstanding if there was a past practice, and that includes schedule modifications, that includes up to and including suspension. That didn't occur here, but that's all.
Right, but that would be a disciplinary, typically it would be a disciplinary action. So
Well,
if you're a hourly worker, changing your shift and your schedule doesn't affect your paycheck, whereas changing your work hours does. They're very different things, no?
well,
I'm sure, I mean, you appreciate that.
I appreciate that, but respectfully, I'm not sure I agree that changing a shift doesn't affect your paycheck. Because different shifts get paid at different rates. They may work different hours. I mean, there's a host of things that are embodied changing a shift. Also, there's another specific provision. And again, if you look at the letter, you raised the letter to the employees, it tracked closely the language in the management rights clause, noting among other things, safety measures expressly authorized in the management rights clause. The ability both for the employees and their families and members of the community to maintain spacing and safety.
But you wrote this uniform letter to, almost 400 employees at once, right? And it was
That
the
is correct.
same letter to everybody.
There was a general letter and then the implementation was
I
followed
understand.
up with
I'm
individual
only about the
employees.
letter right now. So
Yes.
the same letter to everybody. And it told them there was going to be a reduction in hours
Yes,
uniformly. Everybody got that same letter.
that's
Hours
correct.
are going to be reduced. So when you send a letter that says to everyone hours are going to be reduced, doesn't it assume that there's a baseline that employees were already expecting and that's what was changing?
Well, employees were working various shifts. Some were working
That's not what I'm
part-time.
asking. When you tell people, if I say your pay is being reduced, I'm assuming you know what your pay already is, that we both know what your pay
Right.
is. And when you say your hours are being reduced, there's a common understanding of what the hours are now, and that's what's going to change. Correct?
Correct.
And that common understanding of what those hours were is what the ALJ said was 40 hours. Part-time employees are different. But for those who are full-time, they got this letter, there was a baseline understanding, the ALJ found as a matter of fact to be 40 hours. And the employer itself seems to have assumed that there was a baseline understanding. Maybe you think it was 42 or 39 hours, but that there was a baseline understanding of a settled amount of hours that people work, and that's why it's changed. Otherwise, if hours are changing all the time and no one has any settled expectation about hours, you don't need to send a letter saying things are changing because people would know they're always changing. So the letter sort of
Well-
itself evidence that there was a baseline that is now going to be departed from.
So respectfully, we do not agree that there was a practice. So, and I appreciate the argument here. The contract, whether it had been previously exercised or not, did provide the hospital with this authority to engage unilaterally. That's what the union had agreed to. And the contract did not include guarantee of 40 hours or part-time.
Again,
employees.
this isn't a case about what the contract required. This is
But-
a case about what because there's two ways to create obligations. One is through the contract.
Right.
Another is through custom and practice. And the ALJ and the board said explicitly, this is a custom and practice case. So put aside the language of the contract.
But-
You had a custom and practice. This is what was found, a custom and practice of having people work 40 hours. And it seems that you felt obliged to send a letter to everybody, a uniform letter saying your existing hours are going to go down. Suggests that everybody had a baseline. I think you agreed you have to have a baseline. If you tell people are going to reduce, there's a baseline, and what the ALJ found, as a matter of fact, was what that baseline was. You may disagree with that fact finding, I understand that. But there was a communication here that recognized some existing baseline.
There was a baseline to the extent the hospital had been operating pre-COVID,
Yes.
just as all institutions had been operating.
What was that baseline?
In the letter, it was part-time, some people working under 40 hours, people working over. I mean, it varied. It depended on where they worked. There was a
Why did you
variety
need
of.
to send a letter? If everybody's hours varied all the time, then you were just going to vary them some more.
Exactly, but you
So
have
why'd
to-
you need to send a letter? If
you have-
everybody had any stable assumption about their hours, why did you need a letter?
you have to communicate what the changes are, so people know when to work or when not to work. Just as any organization does. So that's certainly.
If
what
you
was-
have unstable hours, people would already have a system of checking each week or so to figure out what their shifts are going to be, so.
But the
know what their
hospital
hours are gonna
shifts
be.
were changing dramatically per the governor's orders.
Right.
This was not
This was a
irregular-
dramatic change.
This was not a regular work week.
Wait,
That is
you said
correct.
exempt.
Sorry?
I thought the hospitals were exempt from the governor's.
There were,
Yeah.
thanks. There were very specific requirements in terms of essential services addressing hospital obligations that modified hospital operations. So essentially, they were down to COVID-related operations and other, necessary treatment, which was reflected certain components of the hospital. Their hours weren't changed in order to respond to this. The environmental unit, the intensive care unit, respiratory, the laboratory work. Other sections of the hospital were reduced, some by 1 day a week, some by 2 days a week. And it depended. And similarly, management employees were affected in a similar fashion, depending on where they were there.
And your argument, just to make sure that I've given you a chance on the preservation of the point, was that in your view, the board's position didn't crystallize until its primary brief, and that's why you didn't challenge whether there was substantial evidence to support the past practice of 40 hours until your reply brief?
Correct, with respect to the practice, because candidly, we had understood the advancement which the board, we think, has now abandoned to be trying to interpret the 40-hour provision as a contractual mandate, which it obviously is not. And I think the parties are aligned on this thing. I mean, the board's decision, one lengthy footnote, which I'm sure everyone has read several times, is somewhat confusing, I think. That's how we understood it.
And the ALJ made findings on both a contract claim and a unilateral change claim.
The ALJ made a number of findings, including, which again, the board has abandoned. The ALJ made findings with respect to COVID. The board has been in exigent circumstances. It appears that the board has backed away from that and said, no, it's really more of an economic consideration. So I respectfully, I find some of the rulings to be, the board's rulings didn't just adopt the ALJ. They substantively modified, I believe, some of the findings, actual findings, as well as certainly the reasoning that was deployed.
You don't dispute that the board's allowed to do that.
Pardon me?
You don't dispute that the board is allowed to do that.
The board in its review of the ALJ decision, well, I would dispute if they modify factual findings respectfully, yes. That is highly unusual. Typically,
The board lacks the power to make its own.
well, it doesn't have the benefit, obviously, of witnesses and
Just
credibility.
asking about their power. Are you challenging? I didn't understand you being
No,
challenging.
I'm
their power.
not challenging them. I'm just noting that.
Got it.
But thank you for that.
Okay, Mr. Courtney, you've gone over your time, but
Yes.
I just
sorry.
want to make clear, under this exigent circumstances argument, the time, the so-called delay between when you were ordered to stop elective surgery and so forth, and just close down for the COVID patients. What was the period of time between that third order and
So the governor,
you sent the notice on April 14th, right, to the employees?
So the governor had issued, there were, I'll call them rolling executive orders. The first one was for 2 weeks. Let's go back. We all know there was great uncertainty as to what this situation was. That was an order of 2 weeks duration. Then the second executive order was issued at the conclusion for another 2 weeks. Then a third executive order was issued that was much more open-ended, which basically said, look, 3 weeks or until this situation is addressed. That's a paraphrase.
What was the date of that one?
That is,
I have 3:30, but
let's see, that is 3:30. I'm sorry, 412 is the executive order number 3. And the first general letter that Judge Millett, you raised, went out on 2 days later on April 14th. And then there was follow-up with the necessarily impacted both bargaining unit and non-bargaining unit.
So is it fair to say that the third order told you, cut out the elective surgery, do whatever you can do, shut down basically except for COVID, and 2 days later you sent the letter
Yes,
to the employees?
yes.
Okay. The other question I had was about these interim earnings. The board says in footnote 5, distinguishing this case from applying the OGLE protection formula because interim earnings are not involved in this case. That's wrong, isn't it?
I think it is wrong. I mean, OGLE, again, the ALJ, these are all, interestingly, everyone citing this case was in Puerto Rico at the time. The case, by the way, was heard via Zoom call. People still weren't in person a year later when this was adjudicated. OGLE was not ordered except by the board. Yes, the board has authority, but the predicate requirements to impose the OGLE factors, which is a detailed factual hearing, which this court has said in Deming Hospital Corp is what should be followed, has not occurred. And FW Woolworth, remember, these were folks that were just for 1 or 2 days for a period of several weeks, several months, were impacted by this decision. So it does feel, OGLE has candidly, a bit of a punitive component to it. And under the circumstances of compliance with a governor's executive order seems wholly inappropriate, not to mention that the requisite findings are lacking.
We'll give you a couple minutes in reply.
Thank you.
Mr. Francisco Fitzmaurice.
Good morning. May it please the court. I'm Brady Francisco Fitzmaurice for the National Labor Relations Board.
Can I just ask you at the beginning, just to get it in? Do you agree this was a 2-day delay between the final order that said shut it down except with respect to COVID patients, and they sent a letter out 2 days later?
Excuse me, Your Honor. The dates I believe that were discussed are correct. There was an initial order from the governor of Puerto Rico in mid-March that lasted 2 weeks, a second one 2 weeks later that lasted 2 weeks, and then a third as discussed by Brother Counsel. So that is correct. That goes to the issue of exigency. And the board's finding here was that they analyzed the hospital's claim, which was they expected to suffer operating losses if they continued to schedule 40-hour weeks for all their employees as had been done. And the board took that at face value and said, under controlling board law, expected or even actual operating losses would be insufficient to establish exigency.
Well, how is that different from the case, and I don't recall the name, with the hurricane where that was an exigent circumstance?
Well, I believe in the hurricane case, there was an evacuation order in place.
Is that what it would take in your opinion, in the board's opinion, do you think?
I mean, under controlling board law, that is sufficient, for sure. That's not what we have here. There was no evacuation order. The hospital was allowed to continue its operations, and it should be noted this was a pandemic. Of course, the hospital should have and could have continued its operations. And also to note that the board didn't find that the hospital could not reduce hours. What the board found was there's a bargaining obligation. And if the hospital found that it needed to reduce hours, it could do so within the confines of the act, which requires notifying the employee's collective bargaining representative and providing an opportunity to bargain over that decision. The facts here show that the hospital rather didn't notify the union at all, directly informed its employees and did not bargain over that decision or the effects of that decision. So I'll just note that the issue as noted by the court is whether there was a regular and longstanding practice of scheduling employees 40 hours a week, such that it constituted the status quo. I won't dwell on this because it's already been noted by the court, but this issue was not raised in the opening brief of the hospital and should be deemed waived. And it's also hard to wrap your brain around, given that the hospital admits it implemented a change. That raises the question, change from what? Obviously, there was an understanding in place that employees were to regularly work 40 hours per week. This wasn't only crystallized in the board's opening brief before this court, as has been mentioned. This was integral to the litigation throughout. I'll draw the court's attention to the complaint, the administrative complaint before the administrative law judge, which alleged that the hospital, quote, reduced the regular working hours, 40 hours per week, to fewer hours per week, without a notice and an opportunity to bargain. After that complaint, the hospital filed an answer in which they argued they had provided adequate notice and opportunity to bargain. You can find those quotes at pages 15, 29, and 43 of the joint appendix. So there was really no question about what the theory of this case was from day one. And in the board's decision and order, what the board found was a violation of Section 885 because of a failure to provide notice and opportunity to bargain. If the board reaches the question of substantial evidence, there was plenty in the record here. There was the testimony of two different witnesses. One worked in X-ray, one was a nurse. Both testified that they had worked 40 hours per week for their entire careers. The X-ray.
I have to say, this seems like incredibly thin evidence that you're talking about 400 some employees. You have two people say, we work 40 hours a week. They have one person who says, I didn't, mine went up and down. And then you had records from April 2 weeks of records from April 2020. You're trying to show a long-standing custom, and the only pay records, or the only hour records you have are from the end. And you don't show any beginning. How can that be substantial evidence?
So I'll note a few things. The question here is whether practice was regular and long-standing.
Such that it creates an expectation in the employees.
Correct. And first, to take the testimony of the two witnesses, it is true. These were two witnesses that gave testimony. The X-ray technician, Ms. Rodriguez-Vicens, had worked for 33 years. So her testimony, I think is worthy of substantial weight.
One person out of 400, and you've got 4 different contracts here. She's only one of the contracts.
She's one, and then Nurse Ruiz Bonet worked for 5 years as well.
5 years.
So I understand that these are two out of...
One witness with 30-something years, they have a witness that wasn't stable. And then one person says, well, for 5 years, I've been stable.
So
Nobody speaks to the other groups that are covered by their own separate contracts. How is that? And then your only work records are from April 2020. How is that sufficient to show a longstanding custom and practice?
Well, I think the longstanding issue, goes to the testimony of those employees, but the work schedules that Your Honor mentions from April 2020, before the change was implemented, show that regular 40-hour work weeks, 5 days a week, 8 hours each, followed by 2 days off, as bargained for by the parties in the contract, was the norm. And that those records at General Counsel Exhibit 10,
Shows us what the norm was in April 2020.
it does, that's correct, but throughout each of the 4 bargaining units, in all aspects of the hospital's operation.
I'm just curious why I would have expected if I were to establish a longstanding customer practice that I would have gone back in time for some records or witnesses and have had more witnesses. Is this commonly sort of all the board has, or was it particularly thin here?
Well, I think the court also needs to take into account that the language of the collective bargaining agreement was relied upon by the board as well as evidence of that practice being in place.
What this is, they can't, trying to have their cake and eat it too, saying this is not a contract case. But we're only going to have this tiny amount of evidence and then point to the contract and say it's not a contract case, it's a custom case. But we don't really have, we have very, very, very thin evidence on custom.
I think if I were to add one more thing to the court's consideration is the fact that the hospital has never really seriously
Who
contested.
had the burden of proof to establish the custom?
Well, the board bears the burden of proof of
Okay, so
proving
the
any
fact that they didn't
violation.
say anything doesn't really matter, does it?
Substantial evidence is the board's burden, for sure. I agree with Your Honor.
Right.
But, in this case, we have uncontroverted testimony. We have documentary
It
evidence.
was an uncontroverted testimony. They had their own witness who said, no, I get sent home when there's not enough work.
Respectfully, I would disagree with the characterization. I don't think that that's controverting the testimony. Testimony of that witness was that I think 2 or 3 times per year had been sent home early. This goes to really the crux of the difference between a contract violation of awarded minimum hours versus what the practice was of scheduling 40 hours per week. There's no claim here that employees are entitled to 40 times their hourly rate every week, regardless of what hours they work. There's no claim here that they're entitled to actually work 40 hours every single week. If there's no work on a given day occasionally, the practice was that employees had been sent home. What the practice was putting workers on the schedule for 40 hours per week. And that finding is uncontroversial.
Well, how does this work if you get to the compliance stage? At that point, do they get to put on evidence that says, actually, 40% of our employees only work 35 hours a week, and they introduce because they'll have to come forward then, or does this order require under Ogle that they get their back pay, their compensation is for 40 hours a week?
Certainly at the compliance stage, the board would have to look at evidence of what employees were actually earning over time, especially given the fact, uncontroverted, that some employees worked part-time hours. So that's part of.
I'm talking about the not part-time workers, but the ones who were not designated part-time, but were not, in fact, always working 40 hours.
Certainly. So what the board's order requires is that the hospital rescind its change to scheduled hours and make employees whole for that change. Certainly in my mind, making employees whole for the change to scheduled hours would not necessarily mean making sure they've been paid for precisely 40 hours for every week after the change had been put.
But the burden of proof is going to be on the hospital at the compliance. Or is it on the board or general counsel?
That's a good question, Your Honor. I don't want to speak out of turn, and I'm not certain.
And then with you just mentioned that the part of the relief that you want enforced is in order to rescind the change in the terms and conditions of employment, the hour changes that were unilaterally implemented, and to bargain over them. But the hospital said in its answer to the general counsel's complaint, these hours of changes have already been rescinded. So as to that aspect of the board's order, isn't it moot? There's nothing to rescind, bargaining to be done.
Respectfully, I would disagree. The board's order includes a cease and desist order, which.
What are they going to cease and desist? They've already rescinded it. Is there any evidence that they had any ongoing violation?
Not in the record, Your Honor, but the order
How can
would,
we affirm that?
the order would impose an ongoing obligation to refrain from similar or related unfair labor.
That's just what the law requires. I mean, it's an ongoing obligation to comply with the law.
It's an ongoing obligation imposed by an order that's now enforced by this court to abide by the law, which in other instances would be administered by the NLRB, which, as you know, cannot enforce its own orders.
But there's no record that they have any practice of ongoing violations. In fact, and you know, they've been in business all these years. It's not like this is becoming to someone who's got a repeat player of engaging in unfair labor practices. This is what COVID happened. They had a response. The board says, we weren't allowed to respond that way. They say, look, we've rescinded it all. Everyone's hours are back. There is nothing for us to bargain over a past event that's been undone. You have your, you know, relief on making people whole, but I'm not sure what record there is to say they need to be under some sort of ongoing court supervision for compliance going forward without any showing that there's any risk whatsoever that they're going to, they never had a pattern of not negotiating in the past.
I hear your point, Your Honor. I think the first response I would have is that this is an argument not raised by the hospital and hasn't been briefed.
Mhm.
I know that there is circuit court case law on this. Having not briefed
But
it.
you're the ones who are asking for enforcement of the order. You have a cross appeal here, and so you didn't brief why we should enforce that aspect of the order. You have an affirmative showing to make as a cross appellant.
Certainly, and I'll rest on my statement that there's an ongoing obligation imposed by the board's order. And if Your Honor would like supplementary case law on that, I can certainly follow up after the argument. I see that I'm past time. I would like the opportunity to address Ogle very briefly since it was raised by Judge Henderson.
Very briefly.
Okay. Just to note that this was an issue that Ogle was imposed by the administrative law judge in the first instance. And so it was at issue in the administrative litigation. It was not opposed by the hospital in its exceptions to the board or in its answering brief, the general counsel's brief to the board. And because that was not raised, it's barred at this point by Section 10E. But in any event, you know, Deming, this court's case fully supports application of Ogle when there's been no cessation of employment. And that's what happened here. These employees had their hours cut. They continued to work. They had no duty to mitigate their losses. And under the policy rationale set out in the board's community health services case, the board found that the policy favored not subtracting, not offsetting interim earnings from back pay order in this context.
That policy was as to, we don't expect employees in a non-termination or suspension status, just in a layoff status, to go find other work. And so if they happen to pick up some other work, the employer doesn't get that windfall because the windfall has said, the employer has made the choice just to lay off. But here, some of the money they're talking about that they want as an offset is governmental checks, stimulus checks and support checks to help people get through COVID. What is the policy argument that that type of payment shouldn't be offset against what the hospital has to pay?
Certainly. So as a general matter, the board does not deduct unemployment benefits from back pay owed in calculating that remedy. The reason for that is because governmental agencies, whether state or federal, that afford unemployment benefits assistance can claw back those funds. And
Is that the same true for these? I'm talking about the special sort of COVID stimulus checks that people were getting. Is that true for those?
I don't know, Your Honor, to be frank. I know that that's the general policy that's in place. I have no reason to think it would be different for the unemployment benefits that were in place due to COVID.
The board didn't address it.
The board did not, and
Is there evidence of the type of payments that they had? I'm understanding was that there was, but I could be wrong.
no, the record doesn't contain evidence
Okay.
of employees actually receiving this benefit.
And do you know whether the hospital ever got PPP funds? I mean,
The record doesn't disclose that. I don't know. If there are no further questions, the board respectfully
Thank
requests
you.
enforcement before.
Mr. Portney, why don't you take 2 minutes?
Couple of points very quickly. With respect to the three witnesses, Judge Millett, I think you raised this. This was not a hospital witness. This was a witness. It was actually the union representative called by the union who is effectively the agent, the representative of the party to the collective bargaining agreement. He is the one that testified that he wasn't regularly paid 40 hours a week, didn't regularly work a 40-hour work week.
Wait, that's a characterization. He didn't say, I don't regularly work 40 hours a week. He said there's been 2 or 3 times.
Right, but we're talking.
Over a period of a year. So there's a question whether.
But what I'm.
Yeah, no, I understand.
Okay, so
the employer did not call witnesses to establish that it was less than a 40-hour.
And it was the agent of the union,
Exactly.
the agreement that did concede that there wasn't a uniform 40-hour work. That's the only point. I don't think that's disputed.
You said there was the April 12th order and then you issued your letter shortly to employees shortly thereafter.
April 14th. April 12 order and then the April 14th.
But the executive order is April 12th. Yeah, but there was the March 30th order. It's the one that put the ban on elective procedures. So what changed between the March 30th and April 12th executive orders that suddenly created the exigency that didn't exist just with the March 30th order?
The duration, at that point, recall there was, we all, including the hospital, had a learning curve on what COVID meant. The first 2 executive orders were limited in duration to 2 weeks. They were finite. 2 weeks, they expired. So at that point, everyone reading and thinking, maybe this will end in 2 weeks. Obviously, that seems almost silly in retrospect now. But when the third executive order issued, it said 3 weeks or as longer as may be required. It had an open-ended component. And frankly, the experience level was much different. It was clear this wasn't going to, when I say this, COVID wasn't going to end that quickly.
But at the same time, since there was uncertainty, then there was not certainty on your part that you did not have time to notify the union and bargain. You're now in a period of uncertainty on timing. And it was your burden to show that not only had an exigency happened, but in fact, it was so imperiling that you did not have time to notify and or bargain with the union. What evidence did you put in as to that?
Respectfully, the position of the hospital is it had already bargained with the union, resulting in the management rights clause.
Okay,
It
but if
authorized
you lose that argument.
Pardon me?
Okay, right, I understand that. But if
Yes.
you lose that argument, as you know, you lost that before the board. So
Right.
in a world where you don't have that argument, is there anything in the record that asserts or explains why you didn't have time after the April 12th or March 30th executive orders to notify the union and bargain with them, even if it was expedited?
Timing was not the trigger. It was based on the authorized actions in the contract.
Got it.
That was the position of the hospital.
Got it. Okay, I understand.
1 or 2 points quickly. With respect to compelling economic considerations, I just want to point out that the rule is any unforeseen occurrence having a major economic effect requiring the company to take immediate action. That's the board standard. Angelica Healthcare, it's cited.
I just asked you, but you said you had no evidence on need for immediate action.
Okay, maybe we're hung up on the term immediate because we did act reasonably promptly after the
No, immediate action
executive order.
that cannot first be done through notice and bargaining with the union. That's what you have to claim here is that we had to go so fast, we couldn't first notify and do expedited bargaining with the union. We couldn't, that's what you have to show. And that's the part that I'm missing here.
Okay.
And I understand your
We have
contract.
a
argument,
contract
you have to do it,
argument.
But if we put that aside, then we don't have anything.
Right. And then the second argument would be under exigent circumstances, which we have discussed, the COVID crisis informed by the executive order and the experience at that point justified what occurred. With respect, I just want to say one word on the damages point, because and I would represent to the court, these parties have just recently entered into a new collective bargaining agreement. I mean, the mootness of this whole situation, thank heavens, COVID and all of this is in the rearview mirror. So providing information, bargaining over a decision, it is moot. Judge Millett I agree with that.
I didn't say providing information was moot, and I didn't say make.
No, I didn't mean to mischaracterize what you said, but in terms of
All I'm talking
bargaining
about
over
is,
the decision and so forth. That everyone is back to work. Parties, these are
they haven't been made whole financially.
for the 1 to 2 days that they lost during that several week period. That is correct. That is correct. And that would certainly require a much more detailed finding than this record would support. Thank you. We appreciate it. Thank you.
Case number 23-7018, Brotherhood of Railroad Signalmen versus National Railroad Passenger Corporation appellants. Mr. Monroe for the appellant, Mr. Edelman for the appellee.
Morning, Your Honors. Tom Monroe for Amtrak. This is a case involving judicial review, arbitration award under the Railway Labor Act. I have 2 points that I would like to emphasize this morning. First concerns our position that the award can be interpreted as applying industry common law. And the second concerns the union's position that the award must be interpreted applying external principles of jurisdiction. First, with respect to industry common law, I'd like to note that it is undisputed that the party's contract incorporates industry common law. The union does not deny that in its brief, nor does it deny that industry common law incorporates a principle that neither side may pursue hypothetical claims or requests for advisory opinions. So that's the contractual context in which this award was issued. That's the contract that the parties have. It incorporates those principles.
And where did the arbitrator even discuss the contract?
Well, in the arbitrator's award, this is the joint appendix, page 18, the most critical page in the appendix. You have the top of the page. The board first either characterizes Amtrak's argument or is discussing its view of the party's contract. In that paragraph, it is describing exactly the contractual principles.
Which JA page are you on? Sorry.
This is joint appendix, page 18.
18.
All right, you've got the background in your favor. I made a chart of both sides, but in your favor, the arbitrator says when Amtrak bought the Washington Terminal Company, they had to attach a resolution or amendment to the collective bargaining agreement. So that indicates that that has to be done again with the purchase of this REA building.
Yes, Your Honor, that goes to the merits.
Okay, but then the arbitrator speaks, and I think there's on page J17, the arbitrator says that Amtrak responded, this was back in 2015, that signalman work was not within the scope of the current collective bargaining agreement. That's one thing that gives concreteness to this case. The other, there's at least another one, and that's where Judge Friedrich, in her 2017 decision, says that Amtrak has notified the union that they're going to contract out the signalman work. So that's another indication of a case of, if you want to call it a case of controversy, at least an active dispute. Those, at least to me, are the only allusions in the arbitrator's decision to the agreement. The rest of it is in terms of as if the board is a court, saying any first-year law student knows you have to have a case or controversy. And you know that language is advisory opinion beyond the board's jurisdiction. So what about that?
Well, Your Honor, the argument that Amtrak made to the board was not limited to those provisions regarding subcontracting that Your Honor identified.
Okay, you've got to either lean closer.
I'm sorry, Your Honor. Yeah.
We're working on fixing this, but it's very hard for me to hear. I've tried everything.
I apologize, Your Honor.
Okay.
So the party's contract includes not just the written provision subcontracting. It also includes various implied terms derived from industry common law concerning what a claim must contain. And so what Amtrak argued in its submission, and this is at Joint Appendix 33-35, it said, as an initial matter, before you even get to the contract provisions that Your Honor is referencing, the claim is defective. It is procedurally defective because it does not include the necessary elements that a claim must include, including specific claimants.
All right, you're in your claims process argument now. And where in the arbitrator's order is there anything about claims processing, about Rule 56? I mean, she's talking in terms of jurisdiction over and over again.
Your Honor, both sides are pointing to different parts of the award. Right. Yes, absolutely. And I completely agree that if this were a horse race, you would have arguments on both sides. But I don't need to win the horse race. I just need to have a horse. And here, the parts of the award that support our position include this language, again, at the top of page Joint Appendix 18, where she says, the original claim requests what is essentially a declaratory judgment, and then goes on to explain and to cite awards, other arbitration awards, for the principle that the board's function is to resolve claims arising from established or determinable facts and issues. Okay, so that is a characterization of these implied contract terms. She then, in the most important sentence in the award, says, the board agrees with the carrier that the claim is a request for an advisory opinion. That is an application of those contractual principles.
So I have two questions, and really just stepping back just to help orient me to what's at stake. What is at stake on this appeal? Like, the district court remanded this to the board. If Amtrak is correct, presumably the board would just clarify what it meant and tie this common law that you assert to some contract term, maybe mention Rule 56, and or say, yes. So I'm just not sure why you came here instead of going back to the board.
Two reasons, Your Honor. One is that Amtrak won below and is obviously not excited about giving up that victory. But second,
in your view, it would just be a confirmation of that victory.
Correct.
Go back to the board.
If we were able to go back to this panel, and here I need to stray outside the record a bit, and this panel no longer exists, and this arbitrator is no longer practicing, but it's no longer possible for the parties to return to this arbitrator and obtain a clarification of what she meant. So that I think informs Amtrak's reasoning for not wanting to re-arbitrate.
If it's so clear, this is this common law that you say the union doesn't even, I mean, I'm going to ask them the same issue. I don't understand what's at stake in this case, really. But just on your point about this question, whether they're asking for an advisory opinion, I didn't see any opinion, whether the ones in your appendix or there are many on the board's own site, that ever cites Rule 56 or similar language as the source of it. And in fact, there are opinions that refer to it as arising from the statute. And if that's the case, then it isn't encompassed by the highly deferential review of an arbitration award. It's a statutory limitation on the board that we would have to look at. So it puts us in a really awkward position trying to read the tea leaves here and figure out where this comes from.
Which is precisely why there is such broad deference to the arbitrator.
I appreciate that there's broad deference very much, but there's also limits on it, as Judge Friedrich held.
Absolutely. And the fact that this is a contractual basis for the board's ruling can be found in those awards that Amtrak cited, and these are referenced in our brief at page 17. We summarize them. Now, you may read them differently, you may interpret the details of them differently, but they are certainly arguably stating the principle that a claim cannot request an advisory opinion or be hypothetical. And you can certainly understand why the parties would have such a rule. The thousands.
You're talking about the bullets on page 17 about the different awards.
Yes, Your Honor.
Right. But they don't identify contracts as the basis of that. They don't link contractual language, let alone language that parallels the Rule 56 language that you refer to. And that, as I understand, Amtrak didn't argue before the board that Rule 56 was at issue. The board did not so find. Rule 56 came in the court as a way of attaching this anti-advisory opinion principle to something in the contract. And even, I mean, you can help me with this, the notion that that sort of common law of the board is part of a contract. Is that necessarily the case? Or is it where there is a provision that one is trying to interpret, one looks to the board's common law?
I understand your question, Judge Blard. There is no case I'm aware of requiring that there be some express contractual language to incorporate industry common law. Rather, for the better part of 100 years, the railroad industry has maintained collective bargaining agreements that incorporate both express and implied terms. And those implied terms include this industry common law. So to your question that those awards don't reference Rule 56 or any other express contract provisions, they don't need to. They are the contract. Arbitral awards, interpreting agreements, are part of the parties' agreement.
And how do we tell that this is contract common law as opposed to, let's say, part of the statute?
Again, Your Honor, it comes back to the narrowest standard known to law. If my position is arguable, if it is conceivable, if it is plausible, if you would not sanction me for arguing that this arbitrator was relying on those contractual principles as opposed to a Article 3 standard or some statutory basis, then the court should affirm the award. And there are no doubt provisions in this award that suggest that she was relying on contractual principles. She cited the award that Amtrak put before her. Amtrak's submission does not say anything about Article 3. It doesn't cite Title 28. It cites exclusively arbitral decisions that form this industry common law. That is the contract.
All right, but at least my reading of the arbitrator order is one PLB was cited, and that was number 1202, which itself appears to be a jurisdictional decision because it states the protest does not involve a named claimant, or dispute and dismissed for lack of jurisdiction.
Your Honor, there's no doubt that for decades, arbitrators have characterized these rules in jurisdictional terms. So that is itself part of the way the parties' contracts refer to these things. That doesn't mean that it is technically legally accurate, but she didn't say, I lack subject matter jurisdiction. She wasn't saying that I'm contradicting Judge Friedrich, and even though this case was sent to me for an interpretation of contract language, this is not a case about interpretation. So there's no conflict.
There's no what?
There's no conflict from with respect to her use of the phrase jurisdiction to define this rule, which again, dozens, if not hundreds of arbitrators before her have so characterized.
So just getting back to there's sort of two issues. One is the, inconsistency with the use of jurisdiction, and the other is whether this is anything arising out of the contract. And going back to that, the rising out of the contract. So if the rule that you refer to, which is this rule against advisory opinions, if it derives from the Railway Labor Act, and I'm reading a board opinion, the Railway Labor Act does not confer authority upon us to grant injunctive relief. Accordingly, the board cannot grant the claim sought in this case. If that's legally correct, it's your position, and that is the source of this restriction. It's your position that doesn't really matter because that could be wrong. It could be the common law of carrier bargaining, that it actually is related to the contracts.
I'm saying that it is at least arguable under Sheehan that this rule has contractual foundations. And
It has
contractual foundations, that that offhand references to the Railway Labor Act that arbitrators may have used in any of these dozens or hundreds of cases that invoke this rule, that there's no case law that they can't point to any statutory provision in the Railway Labor Act against advisory opinions. It doesn't exist. It's a contractual standard. And
So I'm so confused by this case, in part because when it went to the district judge the first time, was this argument not available then? Why wasn't the best position of Amtrak when this case first went to Judge Friedrich on the nature of the dispute? She decided it was minor, not major, but why wouldn't it have been, you're probably wishing this now, why wouldn't it have been Amtrak's position before the district judge? Actually, Judge, neither. It's non-dispute because under the contract, it's not ripe.
A couple of reasons. One, for the most part, there is no such thing as a neither major nor minor. A contract dispute is either a violation of Section 2/7, therefore major, or it implicates the interpretation and application of the agreements, procedural rules or substance. So I don't think it would have been open to Amtrak to say, well, this falls in some sort of nether region. Moreover, it is an interpretation and application of the agreement to decide this on a procedural ground. So there was an arbitration about the application of the contract. It's just that the union's claim was so defective here that what they should have done was refile it with specific claimants. If they had simply listed individuals who they said had been deprived at work, then this issue would not come up.
Before we get to that, though, you say there was an arbitration. Then why wouldn't Amtrak in the very first instance raise this back then? So if it's being arbitrated as minor, Amtrak doesn't raise it. Well, that was after remand from the district court. There was no arbitration in the first place before it went to
Correct.
Yeah,
Correct.
okay.
In the first time the parties were before Judge Friedrich, it was simply on this classification dispute.
So, and it's a little bit unclear to me why this is seen as hypothetical and premature, given that the district court in its first opinion noted that Amtrak had already told the union it would be contracting out the REA building work, including the Signalmen work. It just doesn't seem like it's based on a hypothetical set of facts that has yet to materialize. And in fact, with what we know about labor and employer communications, it seems much better. I mean, certainly this is something the parties could have bargained about. It seems much better if it's a process issue to work it out before Amtrak has gone and contracted out, on the theory that if it doesn't have a right to do that, it would want to know that before it implicates reliance interests of new employees and puts the work into hiring new people. So it's just unclear to me on these facts. What makes this hypothetical? Why is it seeking it? And I know that's, pushing against what the arbitrator found, but just for my edification.
Sure. So there are approximately 4,000 to 5,000 claims brought to the NLRB every year. And 99.9% of them follow the same format. They present a claim on behalf of named individuals with respect to specific relief. So they say Joe Smith and Mary Jones were deprived of work opportunities at the REA building from August 1st to August 30th due to the carrier's improper contracting out. And the relief sought is a day's pay for those individuals each day that they were deprived of those opportunities. That is a proper claim. Problem here was that the union didn't file that kind of claim. It was so eager to, I suppose, get this dispute before the board that it simply sought this generalized kind of "you've refused to acknowledge" claim, which no arbitrator, in my experience, has ever found to be appropriate.
It was so eager to get to the board because Amtrak had told them it was outside the scope of the agreement.
Yes, Your Honor. And they had every opportunity to do exactly what I just described and to file a claim that listed the claimants and requested the relief.
Why wouldn't that be hypothetical? Why wouldn't the union bringing it on behalf of Joe Jones, who hasn't been deprived of any signalman work yet because Amtrak has simply said, we're not going to give it to you. It's outside the scope of the agreement. Then you have Judge Friedrich saying that you all told them it was going to be contracted out. I mean,
well, the
how
way
could they find a signalman who said I was deprived?
Sure. So the way these subcontracting rules work is if the union contends that there's a violation, they bring a claim on behalf of the individuals, either, I can't remember if it's the top of the seniority list or the bottom of the seniority list, and contend that they were effectively deprived of work opportunity.
It would be the bottom because those would be the first laid off.
Although in most of these cases, no one has been laid off. Everyone is fully occupied, and the union nevertheless can bring a claim saying that we should have nevertheless been given that work. But under these long-standing implied terms, past practice, custom of the parties, the way these things are presented to the board is on behalf of a list of named individuals.
So why does that make any sense? If Amtrak's position is none of you, not a one of you, get any work. And so the union comes in and says, do I need to list the name of every single member? Do I need to kill trees doing that? What I'm here to say is they have said, none of us get this work. Why does it matter whether they've named them rather than saying that all of our signalmen have been excluded from this work? Why should that make any difference?
Because for decades under the parties' agreements, these claims are always decided on specific facts.
Is that because all those claims where they had specifically named people also involved railroads saying, none of you, not one of you is going to get any work?
I mean, that's really a question as to whether the agreement that the parties.
No, I'm asking you the content. You refer to these practices where they name people. Does that apply when there's been a flat denial that this is even covered by the contract? None of you get any.
Absolutely.
And so what's wrong with them just saying, we're here on behalf of all of them that didn't get work? We don't have to name them. I don't understand why there's nothing hypothetical about that.
Well, it's just like, I can't bring a complaint in federal court that says, I'm generally upset about.
Yeah, we're governed by Article 3. The arbitrators aren't.
But the arbitrator is governed by the collective bargaining agreement. And the collective bargaining agreement has rules.
It requires there be a dispute.
It also requires.
I don't know where it says that you have to, where it says, have any of these past cases said you must list people by name, even if it's every single member that's affected?
They say that you must present a claim involving specific violations, specific contentions supported by specific.
That's what they've got here, specific violation. You're refusing to even acknowledge a contract's covered. Specific circumstances, new building, you're saying it's completely out. And here's the consequences. None of our people are getting any work. I don't know what's not specific about that.
But Your Honor, that is
He came in and said all of our membership has been blocked off from working, we might even find Article 3 jurisdiction there, right? We wouldn't require them to list every single member. They can speak on behalf of their membership.
So the contract has some rule regarding what a claim must contain. If
You didn't argue that.
we absolutely.
You didn't argue Rule 56. You didn't cite it.
No. We cited industry common law.
But you didn't argue Rule 50. You're talking about the contract term. Are you talking about the Rule 56? Or you're just talking about the arbitration term, the precedents, right?
I'm talking about, so Amtrak absolutely invoked industry common law.
No, but you didn't, I thought you were talking about Rule 56 when you said.
No, Your Honor. Rule 56 is sort of an additional fact that supports the contractual basis of the claim. But if what Your Honor is saying that the arbitrator got it wrong and that the claim that the union presented was good enough, that's just error. That's just an erroneous application of the agreement, which is never reviewed. But in other words, as Judge Posner said in Hill, we're not here to assess whether the arbitrator did their job well. We're just simply here to decide whether they were interpreting the contract. And here, the real dispute comes down to, can you interpret this award as having some contractual foundation? Or is the only way to read this by pointing to the specific parts of it that refer to jurisdiction? My argument is that while you can look at the fundamental principle of jurisprudence and the language about beyond the board's jurisdiction, the other things that the union is pointing to, it is equally, if not more plausible, to look at the fact that the board says, we agree with the carrier. That's an agreement with the argument that the carrier made. And under this court's decision in Verizon, that is contract interpretation.
We agree with the carrier. What was the rest of that?
The board agrees with the carrier that the claim is a request for an advisory opinion.
And therefore beyond.
And therefore,
the board's
that's
jurisdiction.
And that's the part that the union points to. And my point is that while you can point to specific phrases on both sides, it doesn't matter as long as there's anything in this award that supports our position.
So this is where, I mean, maybe I've already beaten this dead horse, but the Supreme Court in Union Pacific Railroad held that the board cannot impose its own jurisdictional rules. And how are we to be sure that the rule the board imposed here is not actually jurisdictional? It refers to jurisdiction. It frames it in jurisdictional language. What's the standard that we should use for determining whether the board is implementing a procedural claims processing rule versus a jurisdictional?
Well, Your Honor, in Union Pacific, the Supreme Court did not say the board may not characterize contractual rules as jurisdiction. Rather, what it said is that there are some circumstances in which doing so has consequences for the parties. And in that case, the particular problem was that if it were not deemed jurisdictional, the carrier would have forfeited the argument. So it had meaning for the outcome. But there are plenty of circumstances that the Supreme Court has discussed where characterizing an argument as jurisdictional has no consequence. I'll give you one example. In Steel Company, it's a Scalia opinion from 1998.
We're super familiar with that one.
Justice Scalia refers to drive-by jurisdictional ruling. And he says, look, if it doesn't matter, if nothing turns on the designation of it as jurisdictional, then so what? It doesn't make any difference. And we don't overturn arbitration awards because arbitrators use legal terms inaccurately. That was the point of this court's opinion in National Mail Handlers. Arbitrators try to emulate courts at times, and they don't always get it right. But unless you can't say they were interpreting the contract, unless you have to say this arbitrator was applying Article 3 without regard to contract at all, well, then the award must stand, even if you disagree with her reason.
Right, if there's no more questions, we'll give you a couple of minutes.
Thank you.
Mr. Edelman.
I'm Richard Edelman for the Brotherhood of Railroad Signalmen. I do want to address what I think is a fundamental problem with the Amtrak's argument, but maybe I'll start with your question, Your Honor, about why are we here? And we're here because the union filed a complaint under the Railway Labor Act saying this is a major dispute. You have unilaterally changed the collective bargaining. Amtrak said, no, it's at least arguable that we have it, that we have a contract right. It's a minor dispute. You need to take that to arbitration. The union took that exact claim. I know because I basically wrote it and said, this is what we wrote to the district court in the cause of action part of the claim and said, this is what we got told to arbitrate. We're taking it to arbitration. And Amtrak says, no, you don't get to arbitrate that. That thing that we told the district court has to be arbitrated. You can't arbitrate. And then the arbitrator goes and holds, I have no jurisdiction to decide this issue that the district court said is a minor dispute, that as a matter of statute, I'm supposed to decide. And then does it using the word fundamental principles of jurisdiction, civil procedure, case or controversy, as Your Honor has noted. This is stuff we, as lawyers, all know. In fact, she chides people for not knowing what law students ought to know, is using those terms of jurisdiction. And to the extent that Amtrak claims, well, she referred to this PLB 1202, as the district court noted, that is clearly in the discussion of what Amtrak's position is.
But on JA 17, the arbitrator describes the carrier's position as the claim must be dismissed because it is procedurally defective. Not jurisdictionally, procedurally defective.
Well,
She agrees with the carrier's position.
well, no, she agrees with the carrier's position. It's a request for an advisory opinion and then explains why. And the
Right,
point,
that's because
everything above
Procedurally defective to seek an
Well,
advisory opinion.
that she says it's an advisory opinion, then she says why. And just to be clear,
I'm just asking.
everything,
If it's just a question for you, if in one moment the arbitrator describes the carrier position as involving procedural defects, requiring the claim to be dismissed,
well,
or in another section describes it in terms that to courts sound like jurisdictional. So you've got both language from the arbitrator, both of which they say requires dismissal, and then she says, I agree with the carrier. How are we supposed to determine which label that she, having picked both jurisdiction and procedural defect, how are we supposed to choose if, as long as it's 50-50 that it was procedural defect rather than jurisdiction, doesn't that mean the arbitration award stands?
because she didn't pick both. She explained exactly what her ruling was. When you're talking about Joint Appendix 17, that's a recitation of what the railroad's position is. And I suppose to Mr.
Right, no, I understand that, but then how she describes the carrier's position matters because she said the board agrees with the carrier.
But
So that's
then
why it
explain,
matters how she describes it.
plenty of people go into court. In fact, I went into Judge Friedrich's case saying, this is why you ought to vacate the award. Judge Friedrich said, well, I'm not really going there. I'm going here. Just because a party advances an argument and the decision maker reaches the result that argument would lead to, but if the decision maker bases it on an entirely different reason, they're not buying the
No, if you
presentation of that
did,
party.
The court said, you should rule for me for reason A and reason B. The district court says, I agree with you. I'm dismissing the case.
It stops right there. That's
So
different
how do we pick which one?
because you don't have to pick which one because she explains exactly here.
I'm asking you that if there's ambiguity, because there's two different descriptions of the same thing, because she describes what the procedural defect is. No claimants, no specific work, no monetary relief. Those are advisory opinion language. So she says, sometimes she calls this advisory opinion because you got no claimant, no specific work, and no requested monetary relief as procedurally defective. And then sometimes she describes it as jurisdictional. And given that, we have to make a decision as to which she was doing. When you have to persuade us that she was going all the way from, it is not a procedural defect, and it is not even a contractual jurisdictional limitation. You have to convince us that she was jumping all the way to a statutory jurisdictional limitation to have vacature.
Right.
And that's the that's, and we have to conclude that. And it's hard to conclude that when she's calling the same thing, sometimes jurisdiction, sometimes procedurally defective.
I don't think she did. I think if you look at what she actually said.
What she exactly said on JA 17. I'd
But
like
JA 17 is just a recitation of what Amtrak says.
say this one more time. Me, maybe not to you, to me. When a judge says, I agree with a party's argument, then the court's description of what that party's argument is matters. Is it your position that I'm incorrect?
No, but I would
Okay,
say, here's
so
what I would.
It matters how she describes, please let me finish. It matters how she describes the party's argument. When she says, I'm agreeing with that. And you're right, she says, I agree it's a request for an advisory opinion. That is what the procedural defect is that she finds. And that's also what she talks about in the language that you do like about jurisdiction.
So, if I may, I think had the arbitrator just written, the board agrees that the claims request for an advisory opinion and therefore beyond the board's jurisdiction, maybe that comes into play. But then she went on to say exactly what she meant. And then she said, and that this is a matter of jurisprudence, case or controversy, all of that.
No.
And she reached the same result as that.
This claim, there's no contention, no evidence the carrier has assigned any communications work at the RIA building to anyone, much less to non-union represented employees. That is restating what she said on JA 17 about why it was procedurally defective. So she's going back and forth.
I don't think
The board
so.
is going back and forth. If I read, okay, then let's try a different thing. If I were to read this as going back and forth, what's the rule of decision for review of arbitrators?
If you believe that the award is ambiguous, you would not vacate. I do not think the award is ambiguous. I think the award is very clear as to here. And I want to point out one other thing.
Can I ask about, you started right where where my attention was, but I felt like you didn't get a chance to complete it. In terms of what's at stake on this appeal for the union, if the problem with the initial grievance was ripeness, is that something you can cure now?
All right.
What's happened
Sure.
since then?
But two things. Let me start with your specific question, as it goes to Mr. Monroe's point about, well, there's no harm here. But there is harm here. There is harm here because if our people aren't, they say you could just file a claim at another point. But if our people aren't in the building, how do we know when the work is being done by a manager or by a contractor? We don't know. We do know that Amtrak has told us, as Your Honor has noted, this is not your work, we're not giving it to you.
I also told you April 2017 letter that says, hey, contract work is underway. Got a contractor doing it and here's what they're doing.
Amtrak sends these notices, and I believe, I'm doing this from memory, so I apologize if it's wrong. My recollection was this is a courtesy notice that we're contracting out this work.
Oh, so that's
That doesn't mean we're going to get a notice the next time.
no, but you've got to notice that they contracted out the work. That certainly makes it more ripe than
And-
before that.
But the point is, we don't know. Our goal of our the beginning of the litigation, everything was to say, you now own this building, your Amtrak. We have a scope rule that we do this type of work. It should be under our agreement. You should agree to that. They said no. But I want to get to the point. If we don't have people in the building, then we don't know when they're violating.
Can you file an information request?
No, there's no information request under the railroad.
Sorry, no. Why couldn't you, under the contract, say, ask them to tell you, you can send a letter every week, every month saying, have you started this? Because that is definitely relevant to an asserted unfair labor practice or bargaining violation. You might be wrong, but that doesn't mean you don't get the information.
There are no information requests. There is no RLA right to information. in order to file a grievance like there is under the NLRA. And also the other point about when you file individual claims. So individual claim, Joe or Ann signal person says on X date, somebody did the work here. And I should get paid 8 hours of overtime. What RLA awards are non-precedential. That does not resolve the question of does the scope rule actually apply there? Because Amtrak would argue in the next case, that's just that case, that person, that day, that specific work. The question that the district court said had to be arbitrated was the question of does the scope rule apply there? And this is another thing I want to point out. The difference between all the awards that Mr. Monroe cited in this case is that all of those were filed on the property, through the grievance procedure. This case came because the district court ruled in their favor on their argument that the claim presented to me must be arbitrated. And that's entirely different from that entire body of law that Mr. Monroe has cited, because the district court under the Conrail case makes the definitive determination, is the case major or minor? And in fact, the case is not minor until a district court says it is. The Supreme Court in Conrail said it is up to the district courts to characterize the dispute as major or minor. Once it did that, it was the statutory duty of the board to decide that issue. And this question of whether or not in cases of individuals filing claims, whether there's a named person involved is different than in that situation. And that's why this case is here. That's why it matters.
So you did argue in your briefing that there's no legal or contractual requirement for there to be a live dispute to grieve or arbitrate a contract interpretation issue. Where do you get that? Because Mr. Monroe has said that you don't dispute, it's undisputed that the contract incorporates industry common law. The board doesn't dispute this industry common law rule, that advisory opinions are beyond the arbitrator's ken.
Well, so I think that rule is frankly nuts and misapplies Article 3. But the point is, in this case was referred from the district court on their motion. Whatever happens when Joe or Ann signal person wants to file a claim or whatever is different than here.
So we need some doctrinal framework for that. I understand the argument that it was referred by the district judge as a minor dispute, not a major dispute. What I take Amtrak's position to be was that, well, all that means is in that categorization, it belongs on this side of the line. That doesn't mean that it necessarily checks all other boxes of procedural adequacy. Now, your response to that could be, well, if this is a non-jurisdictional point, they should have raised that before the district judge and said, actually, whichever side of the line it's on, it's hypothetical. I don't hear you to be arguing that. So it's not clear to me that it's inconsistent to say the dispute is minor, if anything. And then ultimately for the arbitrator to say, actually, there's no live dispute here at all. So help us where doctrinally.
Sure. Doctrinally, it comes from I believe it comes from the Conrail case and from Section 3 of the Railway Labor Act. The board, the NLRB, is created to decide contract interpretation disputes. The court has held in the Chicago River case that arbitration of minor disputes is mandatory. We may not strike over them. The company is obligated to engage in arbitration, and the arbitration awards are enforceable. And then the Supreme Court said that characterization of dispute as major or minor is basically depends initially on the pleading. One party takes its position, and it's up to the district court to decide. They are the classifiers of the dispute. Once the district court did that and said it's a minor dispute, and we took, again, exactly the same claim, the claim that they said is minor. They didn't tell the district court, but if they bring it here, bring it to arbitration, we're going to say it's not arbitrable. So we took to arbitration deliberately the claim that we presented to the district court that the district court said had to be arbitrated. And the arbitrator said, I don't have jurisdiction to hear them. And that, we think, was a decision based did not draw its essence from the agreement. And frankly, beyond that, is a failure of the board to do its duty under the statute, to arbitrate a minor dispute.
If it was erroneous, I mean, just putting aside, let's dial back to before Judge Friedrich characterized this as major or minor. The notion that you might have had to bargain an analog to B11, there was the provision that included another property.
Yes.
If legally that's correct, that you needed to do a bargaining, would that happen under the auspices of major dispute? Would that be facilitated?
If we were bargaining, if we were bargaining to change the agreement, that would be under Section 6 of the Railway Labor Act. That would be a major dispute.
And that, so if the position is that you can't, I guess that you can't, I mean, their position, part of their position on the merits is that this doesn't cover because you haven't bargained for it. Could you just request bargaining on that, or do you have
Sure,
to?
we could do that in the next time we open bargaining, we could do that. But to your point, Your Honor, let them make that argument. You know, they made that argument. The arbitrator should have ruled on that arbitrator. If the arbitrator ruled and said, sorry, union, the scope rule does not apply to this building because in prior cases you did bargain to change the scope rule, and ruled on the merits, then the arbitrator would have performed her duty, would have complied with the referral from the district court, and we would have lost, and we would have gone ahead and then, you know, the next round of bargaining, go ahead and say, okay, now we want to do that.
But was there a way when you originally filed this that had it been characterized as major, you would have had a prompt opportunity then?
So
No.
there is rail collective bargaining agreements have moratorium clauses. So during the period when this occurred, we could not begin Section 6 bargaining. So we could not have served a notice at that time. I mean, I suppose Amtrak could have said, hey, you know what, let's just clear this up and we'll bargain and put this under the agreement with everything else, but they had no obligation to do that or engage with us.
If there are no more questions, I do have a real world question, and that is, has the Signalmen work been done at the REA building? It's been 6 or 7 years since this began.
We don't know. Our people aren't there. We don't know.
It's not something you can.
So the REA building actually is
Right.
along the tracks here at Union Station. It is a separate building.
Right.
And so we don't have any role in that building.
There's
So
no
we
way
don't
to know whether.
We do not know whether the specific work there is being done. And I should also point out, just with regard to the question of a contracting out notice, if they do this with exempt employee managers, they certainly wouldn't give us.
What'd you say? If they did it with managers, what?
They would not give us notice at all.
Oh, yeah.
Even as a courtesy.
And can I ask a quick fact question too? And that is, does your collective bargaining agreement, does it include an arbitration clause, or you just don't even bother with that under this statutory scheme?
So yeah, Railway Labor Act arbitration, unlike NLRA arbitration, is statutory.
And so you don't have.
So we don't have that. And by the way, that's a little bit also goes to the difference between some of these cases where courts talk about arbitrators confusing jurisdiction and procedural. Because if you're under the NLRA, arbitration is contractual. And the question of jurisdiction of the arbitrator there relates to, does the contract actually require you to arbitrate this? Under the Railway Labor Act, there is no question, statutory, if it is a contract
I
interpretation.
understand that. I was just asking if you also had an arbitration.
No, it doesn't duplicate. Thank you, Ron.
Can you finish what you need to say in 2 minutes?
Yes, Your Honor.
Okay.
Very quickly, let me address Mr. Edelman's primary argument, which is that once the district court decided this was minor, it had to be decided on the merits. I'm not aware of any case that has ever said that a referral of a matter to arbitration means the carrier has waived its procedural defenses. If this board had said we lack subject matter jurisdiction because this is a statutory dispute or not a question of interpretation of the agreement, I would agree with Mr. Edelman. But there's nothing in this award that even remotely suggests that that was what the board was doing. As this court has said, parties and courts and arbitrators use the phrase jurisdiction to mean all kinds of things: personal, subject matter, Article 3 standing, venue. It can even refer to the kinds of relief that a tribunal can authorize. So there's nothing here to suggest that the board was saying something inconsistent with Judge Friedrich's decision.
Can you answer Judge Henderson's question? If there was any signalman work in this building, is it done?
I actually, it's not in the record and I don't know, Your Honor, but I will say this.
It's been a long time.
I'm sorry?
It's been a long time since you started contract work.
It is literally not in the record. I have no idea, but I can say this. It is astonishing to me that the union would suggest they have no idea, because one of the most
I
fundamental.
have no idea, and it's your building, so I don't know why it's astonishing they don't know.
Well, because it's the union's obligation to police the agreement. It is one of the foundational principles of labor law. They have a collective bargaining agreement. If they believe it's
Are they
being,
supposed to know this?
they can go to the building and see what's happening. I mean, this happens all the time. How do they know that there's subcontracting going
Already in
on?
the building, right?
Sorry?
Your client's already in the building, right?
Again, I mean, it's right over there. Go take a look. They could go at any time. And this happens all the time. I mean, there's contracting out that happens.
Just curious that you expect them to know, but you don't know. That's kind of curious to me. It's your building.
Well, Your Honor, it's just not in the record. So I suppose if I were the vice president of labor relations at Amtrak, maybe I would, but it's just not in the record. So I can't say one or the other. The last point I'll make is to your point, Judge Millett, about if it's 50-50, how do we decide? Well, if it's 50-50, your job is done. The award must stand.
Thank you.
Thank you.